Mr. Coughlin. It's a one-page letter dated November 21st, 2006 to you.
Which exhibit is it?
8.
Okay.
Oh, sorry, 9.
Nine.
I apologize. Do you recognize Exhibit 9?
Yes, I do. It's a letter from you to myself.
I request to have Exhibit 9 moved into evidence.
Have any objection?
No, Your Honor.
Exhibit 9 is moved into evidence.
Let's move on to Exhibit 10. Mr. Coughlin, Exhibit 10 is a 2-page exhibit, and the first page is a letter January 3rd, 2007 to you. Do you recognize Exhibit 10?
Yes, I do.
Okay, how do you recognize it?
It's as you described it.
Is this a letter you received?
I believe so.
I request to have Exhibit 10 moved into evidence.
Any objection?
No, Your Honor.
Exhibit 10 is moved into evidence. Or admitted into evidence.
Okay, let's move to Exhibit 24, please. It's in the next binder. Exhibit 24 is a one-page exhibit. It's a letter dated September 4th, 2003 to Zachary Barker Coughlin from Kathy Crary. Do you recognize Exhibit 24?
Yes, I do. It's as you described it.
Did you receive Exhibit 24?
Yes.
Request to have Exhibit 24 moved into evidence.
No, Your Honor.
Exhibit 24 is moved into evidence. Or admitted into evidence.
Exhibit 29. Exhibit 29 is a 2-page exhibit. The first page is a letter dated May 10th, 2004 to Kathy Crary from Jerome Fishkin. The second page is a report of Robert E. Hunter, Ph.D., dated May 21st, 2002. Do you recognize Exhibit 29?
Yes, I do. It's as you described it.
I request to have Exhibit 29 moved into evidence.
Any objection?
No, Your Honor.
Exhibit 29 is moved into evidence.
Please turn to Exhibit 31. Exhibit 31 is a one-page letter dated May 27, 2004 to Jerome Fishkin from Deborah Murphy Lawson. Do you recognize Exhibit 31?
Yes, I do.
I request to have Exhibit 31 moved into evidence.
Is there any objection?
No, Your Honor.
Exhibit 31 is moved into evidence. Is admitted into evidence.
Please turn to Exhibit 37, Mr. Coughlin. Exhibit 37 is a 3-page exhibit. The first page is a letter dated July 13, 2004 to Jerome Fishkin from Deborah Lawson. And the third page of the exhibit is a stipulation pursuant to Rule 10, Section 4. Do you recognize Exhibit 37?
Yes, I do.
I request- How do you recognize it?
It's as you described it.
I request to have Exhibit 37 moved into evidence.
Any objection?
No, Your Honor.
Exhibit 37 is admitted into evidence.
Exhibit 38, please turn to. Exhibit 38 is a 2-page exhibit. The first page is dated July 22nd, 2004 to Deborah Murphy Lawson from Jerome Fishkin. The second page of the exhibit is a stipulation pursuant to Rule 10, Section 4, signed by Zachary Coughlin, or Zach Coughlin, on 7/19/04. Do you recognize Exhibit 38?
Yes, I do.
How do you recognize it?
It's as you described it.
I request to have Exhibit 38 moved into
Any
evidence.
objection?
No, Your Honor.
38 is admitted into evidence.
Okay, I'd like to go back to Exhibit 39. I'd like you to review pages 1 through 28 of Exhibit 39. Page 1 is a letter dated January 12, 2005 to Deborah Murphy Lawson from Jerome Fishkin with enclosures. Do you recognize Exhibit 39, pages 1 through 28?
Yes, I do.
I request to have Exhibit 39, pages 1 through 28 moved into evidence.
Is there any objection?
No, Your Honor.
Okay, so is that all of Exhibit 39?
No, it's not. It's just
Okay.
pages 1 through 30,
Okay,
Your Honor.
1 through 30 are admitted.
Your Honor, can I request to have the rest of it added into evidence?
Sure, is there any objection?
I would object to it on the basis of hearsay.
A to F. Let's see, page 39. What I'm going to do right now is not make a ruling at all, and at the end, determine whether it should come in or not. So right now, we have Exhibit 39, pages 1 through 30 coming in. I'm not going to rule on your request as of yet.
Please turn to Exhibit 40. Exhibit 40 is a 4-page exhibit. The first page is a letter to Deborah Lawson dated January 27, 2005 from Jerome Fishkin. And the exhibit contains 2 reports of Oliver Oxgay dated December 11, 2004 and August 16, 2004. Do you recognize this exhibit?
Yes, I do. It's as you described it.
I request to have Exhibit 40 moved into evidence.
Do you have any objection?
No, Your Honor.
Exhibit 40 is moved into evidence.
Okay, Exhibit 41. Oh, I'm sorry.
That's okay, it's admitted. Okay,
thank
Exhibit
you.
41.
Exhibit 41 is a 1-page exhibit. It's a letter dated February 10, 2005 to Jerome Fishkin from Kathy Crary. Do you recognize this exhibit?
Yes, I do.
I request to have Exhibit 41 moved into evidence.
Is there any objection?
No, Your Honor.
Exhibit 41 is admitted into evidence.
Please turn to Exhibit 44. Exhibit 44 is a 5-page exhibit. The first page of the exhibit is a letter dated April 15, 2005 to Deborah Lawson from Jerome Fishkin. And pages 3 through 5 of the exhibit is the order admitting applicant to the State Bar of Nevada. Do you recognize this exhibit?
Yes, I do.
Request to have Exhibit 44 moved into evidence.
Is there any objection?
No, Your Honor.
Exhibit 44 is admitted into evidence.
Exhibit 47. Please turn to Exhibit 47. Exhibit 47 is a 4-page exhibit, and the first page is a letter dated May 12, 2005, from Deborah Lawson to Jerome Fishkin. And page 3 is the Supreme Court, State of Nevada, certificate of Zachary B. Coughlin. Page 4 is a letter dated April 6, 2005, regarding the admission of Zachary B. Coughlin to the State Bar of Nevada. Do you recognize this exhibit?
Yes, I do.
I request to have Exhibit 47 moved into evidence.
Is there any objection?
No, Your Honor.
Exhibit 47 is admitted.
Turn to Exhibit 49, please, Mr. Coughlin. Exhibit 49 is a 1-page exhibit entitled Authorization for Disclosure and Release of Information, signed by Zach Coughlin, 6/24/05. Do you recognize this exhibit?
Yes, I do.
How do you recognize it?
It's as you described it.
I request to have Exhibit 49 moved into evidence.
Is there any objection?
No, Your Honor.
Exhibit 49 is admitted.
Exhibit 50, please turn to. Exhibit 50 is a 1-page exhibit entitled Lawyer Assistance Program Notification of Enrollment. Do you recognize Exhibit 50?
No.
Okay, let's move on. Exhibit 53, please turn to 53.
Okay.
Exhibit 53 is a 1-page exhibit dated November 27, 2001, to Mr. Zachary Coughlin from Philip Burns, Judicial Affairs Officer for UNLV. Do you recognize Exhibit 53?
Yes.
Your
As you described it.
request to have Exhibit 53 moved into evidence.
Is there any objection?
No, Your Honor.
Exhibit 53 is admitted into evidence.
Please turn to Exhibit 54, Mr. Coughlin. Exhibit 54 is a 4-page exhibit. And the first page of the exhibit is dated May 26, 2006, to Deborah Murphy Lawson from Jerome Fishkin. Page 2 is a report of Alan Wong, MD. Page 3 is a report of Mujahid Rasul, MD. And page 4 is a report of Oliver Oxgay, PhD. Do you recognize Exhibit 54?
Yes, I do.
I request to have Exhibit 54 moved into
Is
evidence.
there any objection?
No, Your Honor.
Exhibit 54 is admitted into evidence.
Please turn to Exhibit 55. Exhibit 55 is a 2-page exhibit dated June 7, 2006, to Jerome Fishkin from Deborah Lawson. Do you recognize Exhibit 55?
Yes, I do. It's as you described it.
I request to have Exhibit 55 moved into evidence.
Objection?
No, Your Honor.
Exhibit 55 is admitted.
Please turn to Exhibit 59. Exhibit 59 is a 6-page exhibit. First page is a letter dated September 27, 2001, to Zachary Coughlin from Christine Smith, Associate Dean of Administration and Student Affairs at UNLV. Do you recognize this exhibit?
Yes, I do.
How do you recognize it?
The entire exhibit?
Yes.
It's a letter to me from Christine Smith, followed by an email from her, followed by an email from me to her.
I request to have Exhibit 59 moved into evidence.
Any objection?
No, Your Honor.
50, what is it?
9.
59 is admitted.
Please turn to page 71. Excuse me, Exhibit 71. Exhibit 71 is a 6-page exhibit. Page 2 of the exhibit is a report, starts a report of Douglas E. Tucker, M.D. I request to have Exhibit 71 moved into evidence.
Any objection?
I object because I haven't seen this report.
Okay. So is the objection hearsay or what? What's the objection?
I object because it's hearsay.
Sustain. At this point, I won't let it in until there's a foundation and
Okay. Well, can I go through that now, or? Well, you know what, I'll go through that in a little bit. Okay. Can you please turn to Exhibit 13? Exhibit 13 is the reporter's transcript of proceedings from March 1st, 2002, in the case in re matter of Zachary B. Coughlin, Committee of Moral Character and Fitness, State Bar of Nevada. Do you recognize this exhibit?
Yes.
Was this a transcript of the hearings that you participated in with the State Bar of Nevada?
I'd object. Hearsay.
so you're objecting to 13 coming in?
Oh, I haven't tried to move it into evidence yet, Your Honor.
Okay.
I just asked the question of whether or not this is a transcript of the informal or the formal hearing that Mr. Coughlin participated in with the State Bar of Nevada.
It's just for the March 1st date?
Correct.
Yes, I believe that is it, as you described it.
I request to have Exhibit 13 moved into evidence.
Is there objection?
Object on hearsay.
Okay, I'm going to sustain it on that. I think what you're going to have to do is bring in specific parts that you want in, because not all of it can come in, but most of it can probably come in under other.
Yes, Your Honor. Exhibit 15 is a 118-page exhibit. These were documents that were provided by the State Bar of Nevada in relation to Mr. Coughlin's matter before that committee. I would request to have pages 1 through 106 and 113 through 117 admitted into evidence.
Okay, what pages?
1 through 106.
6, okay. And
113 through 117.
see. Let me look at them. Okay, is there any objection?
Hearsay, Your Honor.
Okay.
I'll limit that.
Okay. What pages?
I'm looking at that right now, Your Honor. One moment, please. Page 29.
Page 29. Page 29, just the affidavit?
Yes.
Okay. You're going to, you want that admitted?
Yes, Your Honor.
Any objection?
No, Your Honor.
Page 29 is admitted as to Exhibit 15.
At this point, I believe that's the only page that I would like to be admitted.
So page 29 of Exhibit 15 is admitted.
Okay. Exhibit 60, please. If you could turn to that. Exhibit 60 is a 27-page exhibit, and the first page is entitled "In the Small Claims Court of Reno Township, County of Washoe, State of Nevada." Do you recognize Exhibit 60?
No.
Your Honor, I request that the court take judicial notice of Exhibit 60. It's a certified court record of Washoe County case number RSC 2005-000301.
Okay. Is there any objection?
Hearsay?
Okay, I'm going to take judicial notice of the fact that there is the Small Claims Court of Reno Township. Okay, so it's judicially noticed, and that would be Exhibit 60 judicially noticed.
Please turn to Exhibit 61. Mr. Coughlin, do you recognize Exhibit 61? It is a 1, 2, 3, 4, 5-page
yes.
exhibit. You do? The first page is entitled "Application for Registration to Practice Before the United States Patent and Trademark Office." You do recognize this exhibit?
Yes, I do.
A request to have Exhibit 61 moved into evidence.
Is there any objection?
No, Your Honor.
Okay, 61 is admitted.
Your Honor, I'm sorry to ask you again, but can I use the restroom?
Sure.
I'm sorry.
We'll take a 5-minute break.
Thank you.
request to have Exhibit 67 moved into evidence.
Any objection?
Hearsay?
This is a certified copy, is it?
Yes. For the first page.
The court will take judicial notice of 67.
Please turn to Exhibit 68. Exhibit 68 is a 2-page exhibit. It's a certified copy of the toxicology report in relation to Zachary Coughlin. Do you recognize this exhibit?
Yes, I do.
Request to have Exhibit 68 moved into evidence.
Any objection?
Hearsay?
Okay, and the court will take judicial notice of the fact that there is a toxicology report. That's the only thing I'm taking notice of. I mean, all the other stuff in the report may be hearsay.
Okay. Can we please turn to Exhibit 72? Exhibit 72 is a 101-page exhibit.
We already have page 33 through 57
Yes.
admitted. Okay.
Actually, strike that. Mr. Coughlin, did you attend an evaluation with Douglas Tucker on April 27, 2007?
Yes, I did.
And was that based on this court ordering you to attend that evaluation?
Yes.
And as part of that evaluation, did Dr. Tucker examine you?
I'm sorry, are we done admitting?
Well, I specifically want to turn to Exhibit 71.
Okay. Yes, Dr. Tucker did examine me.
And as part of that examination, did you take part in a 3-hour and 10-minute interview with Dr. Tucker?
I believe it was roughly that length.
And as part of that examination, did Dr. Tucker advise you that he would be issuing a report?
Yes, he did.
Can you review Exhibit 71? And advise whether or not this is the report that Dr. Tucker issued regarding your evaluation on April 27, 2007?
I can't advise you that. This is the first time I've ever seen this report. I couldn't advise you of that, I don't think.
Did Dr. Tucker provide a copy of the report to you?
Not to my knowledge. Not yet, at least.
And at this point, are you objecting to the admissibility of this report?
Yes.
Mr. Coughlin, you passed the July 2001 Nevada Bar examination, correct?
Yes.
And you passed the July 2002 California bar examination.
Yes.
On February 2nd, 2001, you filed an application for admission to the State Bar of Nevada.
Yes, that's correct.
Okay, and that's represented by Exhibit 4.
Yes.
And then on December 18th, 2002, the Nevada Supreme Court issued an order deferring your admission to the State Bar of Nevada.
I'm sorry, what was that date?
December 18th, 2002.
It's the date on their order. Yes.
Deferring your admission.
Yeah.
On March 25th, 2005, the Nevada Supreme Court issued an order of admission conditioned on your compliance with certain conditions for a period of 3 years, including a condition that you attend counseling with a licensed Ph.D. psychologist.
That's correct.
Your conditional admission with the Supreme Court of Nevada will terminate 3/25/08.
That's correct.
Okay, I'd like you to turn to Exhibit 1, please, and this is your original application to the State Bar of Nevada. Please turn to page 17 of that exhibit. Page 17 and page 18 are an authorization and release. Did you read this authorization and release?
What exhibit's that?
I'm sorry, it's Exhibit 1, pages 17 through 18.
Sorry, did I read it?
Did you read this authorization and release before signing it?
I can't recall.
Would this be something that you wouldn't read before signing?
I don't understand your question.
You did sign this document, correct?
I believe so.
On September 23rd, 2002?
That's what it looks like.
And on page 17, in the bolded language in the first paragraph, it states, I have carefully read the questions in the foregoing application, have answered them truthfully, fully, and completely, without mental reservations of any kind. Fully understand that failure to make full disclosure of any fact or information called for may result in the denial of my application and receipt of an adverse moral character determination. I therefore agree to give the committee, through the State Bar's Office of Admissions, any further information which may be required in reference to such investigation.
I'm sorry, you're saying that's all in bold?
No, I'm sorry. The first part was in bold. The rest, starting with I therefore agree, is not in bold. That's what the document says, correct?
Yes.
Okay, and page 18 of the document, paragraph 3, it states, I also understand that pursuant to Rule 6, Section 7 of the Rules Regulating Admission to the Practice of Law in California, I am under a continuing obligation to keep my application current and must update, and this is in bold, in writing, my responses to the application whenever there is an addition to or a change to information previously furnished the committee. Correct?
That is what it says.
And the last paragraph states, I hereby declare under penalty of perjury under the laws of the State of California that the answers and statements provided by me in the foregoing application are true and correct.
That's what it says.
Why are there two signatures at the bottom, Mr. Coughlin?
I don't know.
Are both of those your signatures?
I believe so, but I'm not sure.
You're not sure whether or not that's your signature?
No, I'm not sure.
Can you explain that, how you're not sure?
I don't know how anybody could be sure something's their signature. They can,
Well, you could be reasonably sure.
yeah.
Okay. So you're reasonably sure it's your signature, right?
Yeah, I don't understand why there's two of them. That has me a little confused, but they both do look like my handwriting.
I'd like to go to page 4 of that exhibit, of Exhibit 1. Page 4, under employment history. I want you to show me where under that section you listed your employment with the law school library.
Page 4.
Yes. Well, page 4 starts employment history, but under that section, I want you to show me where that your employment with the law school library is listed.
Page 4. Where it says all your employment which is or was law related? That question?
Yes.
And your question is, why would working in a library be under a law related?
No, my question was, I want you to point out where your law library related employment was listed. It's not listed, is it?
I don't believe it's called for.
Okay. Do you see under employment history where it says, and this is approximately 4 sentences in, also list, to the best of your recollection, all of your employment, business, occupations, and professions which were not law-related but lasted longer than 6 months since your 18th birthday?
Yes.
You worked at the law library from from October 1999 to May 2000?
I'm not sure of that.
Is there something that would refresh your recollection about that?
Paycheck stubs.
What about your application to the Nevada Bar? That's Exhibit 4, where you state on page 16 of that exhibit, at the top, month and year of beginning and ending employment period from 1099 to 5/2000, University Nevada Las Vegas Law Library. Would that refresh your recollection?
That would serve as a general indicator, but that wouldn't necessarily mean that those dates are accurate.
Didn't you confirm those dates at the formal hearing before the committee on March 1st, 2002?
I don't recall. Formal? That would be before the Nevada Committee.
Correct. What do you think the dates of employment are?
Roughly those dates, however, I believe I didn't work over the winter break. And I think those dates are rough estimates.
Would you agree that October 99 through May 2000 is over 6 months?
Not if there was an extended break in between those.
In fact, in your update to your application exhibit, which is Exhibit 3,
And actually, one second.
Okay. Is there a question?
I thought he said actually something that he was, I'm sorry.
Okay.
Did you have something to finish?
Well, I'm just saying, say it was, let's say hypothetically it was, you started on the 31st of October and you ended on the 1st of May. And even without a break, I would take it in November. So I don't know whether or not it would be 6 months.
But are those dates of 1099 through May 2000 accurate?
I don't know.
In fact, in your application, your update to your application in February 15, 2007, at page 2, you wrote that I was not employed at the law library for an extended period during the winter break from classes in December 1999 through January 2000.
Yes, I believe that's true.
So are you saying that those are the dates of your employment?
No, I'm saying when you worked there and they closed for the winter break, that wasn't working there while they were closed.
Okay, I want you to go back to the application and show me where it says that you're not supposed to list things where there's a break, a winter break, or
Which application?
the application for admission, Exhibit 1.
The Nevada bar? Or to the
No, to
California?
the California bar. Page 4. And I want you to point out where it says, don't list it if there was a break involved in the employment.
Well, it says if it lasted more than 6 months.
So how did you interpret that?
Well, you would add up the period at which you were employed, and if it totaled over 6 months.
So why didn't you put the law school library employment in your application?
It was my belief that it wasn't 6 months and that it wasn't law-related. It wasn't longer than 6 months.
Didn't you actually testify to the,
And it wasn't full-time employment, it was part-time employment. It was
And
something
I-
10 to 12 hours a week.
and I want you to list under employment history, or excuse me, point under employment history on the application where it says that there's a difference between full-time and part-time.
And this is in which application?
Page 4 of Exhibit 1.
And that is the California application?
Yes.
I'm sorry, what's your question again?
I want you to point out where it says that you should differentiate between full-time and part-time employment. Doesn't say that, does it?
I don't know why you're asking me that.
She's just simply asking it, and if you can answer, answer. If you can't, you can't.
Your question is, does it say distinguish between full and part-time employment?
Yes.
I'm not sure that it does say that.
Didn't you testify to the Nevada committee that your employment at the law school pretty much lasted the first year of law school?
I don't recall that.
Let's turn to page 37, or Exhibit 37. Oh, sorry. Exhibit 13, I apologize. Page 37. Starting at line 9, Ms. Story, how long did you work for the law library? The witness, I'm not certain the exact number of months, but it was pretty much the first year of law school. I was working, I was studying there until midnight each night, and the lady who worked there said, why don't you just work here? And I said, well, yeah, that would be great. I could get paid for that, so I worked there for the whole first year, basically. It might not be the entire first year because the first probably month or maybe longer than that, 2-3 months, I can't remember. I wasn't working there. You testified to that?
I believe so. That's what it says.
So you actually worked there for longer than just a few months, didn't you?
Well, I don't know. I mean, if the school year is like 8 months and I say maybe I didn't work there the first 3 months, then, what was your question again?
So let me get this straight. The reason why you didn't list the law library employment on the application to California was because you didn't believe it was over a period of 6 months?
I didn't believe it fit within what was called for by the application.
Did you ever ask anyone about what was called for by the application?
I can't recall.
Did you have any help with filling out the application?
I can't recall.
What would have made it, in your opinion, relevant to put in that application then?
What would have made what relevant?
If the employment was for the actual first year, would you have put it in the application?
If I felt that it fit within what was called for by the application, I would have put it in.
What do you feel that wasn't called for?
I don't understand your question.
What did you feel you could leave out of the application in that section?
The things that weren't called for by it.
Can you define what you mean by that, Mr. Coughlin?
I'd object for vagueness in the leading question.
Okay, well,
Okay, I'm going to sustain it in terms of vagueness, or maybe,
I'll rephrase it.
yeah, why don't you rephrase it?
Mr. Coughlin, you just testified that you didn't believe putting the law library employment was called for in the application, correct?
That's correct.
Now, can you explain what you mean by that?
The question called for listing employment that fit within a certain description. I didn't feel that the law library clerk job, checking in books, fit within that description called for by the question.
Okay, let's turn to page 8 of Exhibit 1. Page 8 is entitled Credentials and Licenses. The first paragraph reads, have you ever applied for and then withdrawn an application or held a license for business, trade, or profession other than as an attorney at law, the procurement of which required proof of good character and or examination, e.g., certified public accountant, patent practitioner, or real estate broker? You answered no to that section, correct?
That's correct.
And this was an application that you turned into the State Bar or submitted September 28, 2002?
I believe so, yes.
Okay. Yet you took an exam for licensing before the U.S. Patent and Trademark Office in July of 2002, correct?
I believe so.
You didn't pass that test, did you?
I'm not sure.
And then
I'd say I'm not sure because there was a appeal that I made that was never resolved because I passed a subsequent test. So I don't know whether I didn't pass it or not. That was rendered mute by me passing this.
okay, but you passed the October 16, 2002 test, correct?
Yes.
And actually, you submitted an application for registration to practice before the United States Patent and Trademark Office on July 9, 2002, correct?
I'm not sure about that.
Let's turn to Exhibit 61, shall we? Exhibit 61 is the application for registration to practice before the United States Patent and Trademark Office, and it's stamped received July 9, 2002. Do you see Exhibit 61?
Yes.
Okay. Would it be fair to say then you submitted an application that was filed or received July 9, 2002?
I don't know.
What don't you know, Mr. Coughlin?
I'm not sure whether that would fit, whether there's a more extensive phase of the application. So I don't know.
Wait, I don't understand your statement. My question was, you submitted this application to the U.S. Patent and Trademark Office, which was received by the office July 9, 2002, correct?
I believe so.
Yeah, you didn't put that in your application to the California State Bar, did you?
Well, I did tell the California State Bar about my involvement with the Patent Office, so...
That wasn't the question. The question is, on page 8 of Exhibit 1, where it asks for credentials and licenses, you didn't state or put in any evidence that you were, in fact, applying for and taking an examination before the U.S. Patent Office.
I'm sorry, what was your question?
You didn't put under the section entitled Credentials and Licenses any information about the U.S. Patent Office, did you?
I object to the form of the question.
Overruled.
I don't have anything listed there.
Why did you not list that?
I don't know. I don't know whether this qualifies as applying for or having applied for. If the application phase has become past tense, i.e. applied would qualify, rather than are you currently applying for.
So was the question ambiguous to you?
I don't know.
Did you ask anybody to help you with the question?
I can't recall.
You just decided to unilaterally not put the U.S. patent information into your application?
Well, I do believe the U.S. patent application was put into my application.
But that wasn't actually until May 31st, 2004. Isn't that correct? Almost 6 months after you passed the examination?
I'm not sure of that.
Let's see. You passed the examination on October 10th, 2002. That's what you just testified to, correct?
I believe I took an examination on that day. I don't know that the results were given on that day.
Okay, so you took the examination October 16th, 2002?
I'm not sure about that.
Let's turn to Exhibit 61, page 3. First sentence, upon further review, your application past October 16th, 2002 examination for registration can now be processed. Do you see that?
I'm sorry, what exhibit was that?
Exhibit 61, page 3.
And your question? I'm sorry.
It says, upon further review, it's a letter dated March 28, 2003, to Zachary B. Coughlin from Shirley A. Brown, Paralegal Specialist, Office of Enrollment and Discipline, United States Patent and Trademark Office. And it states, upon further review, your application past October 16, 2002 examination for registration can now be processed. So you passed the October 16, 2002 examination, correct?
I believe so.
And you were notified that you passed as of March 28, 2003, correct?
No, I don't believe so. I believe I knew I passed the exam prior to that. This is saying that they're now going to license me.
Oh, so you knew that you passed the exam long before March 28, 2003?
I don't know what long would qualify.
But before the state?
I believe so, yes.
Okay. Yeah, you didn't inform the bar anything about the patent examination or your licensing before May 31st, 2004.
I don't know that to be true.
Well, let's look. Exhibit 32 is your May 31st, 2004 update to the bar. And on page 1, it states
I'm sorry, this is Exhibit 2?
32?
32?
Yes. It states approximately 3 paragraphs down, September 2002, December 2002. During this time, I studied for and passed the United States Patent and Trademark Office, USPTO bar exam. I was admitted to practice as a patent agent on May 2nd, 2003. My registration number is 53,905. Also, I perform part-time legal research for an intellectual property law firm, Anderson and Morishita of Las Vegas, Nevada. That was your first update to the State Bar regarding your patent exam, isn't it?
Not that I don't know that. I've had many conversations with Ms. Crary on the phone, and I don't know that that's my first written update either.
Well, what I'd like you to do then is go through, strike that. So your testimony is that you don't know whether or not you may have updated the bar before May 31st, 2004?
I'm not sure. Offhand, I don't know.
And I read to you earlier that you signed off under penalty of
I
perjury.
would object to this, Your Honor, because I don't understand where Ms. Kagan's going with this. This doesn't seem to be...
It goes to the issue of candor and how you filled out the application and what was left out of the application. So the
Well,
objection...
if that's what she's hanging her case on, something like this, I just don't see where this rises to the level of these proceedings.
Well, she has to put in her case, and she's putting on her case of
And this is what
bad
she's
moral-
leading with.
Yes, this is the question she's asking.
Some case.
Hey, Mr. Coughlin, in that letter that I just read to you, Exhibit 32, it does state, correct, that it's you've mentioned the dates. It's September 2002 through December 2002, correct?
I'm sorry, in which letter?
Exhibit 32, the May 31st, 2004 update to the State Bar.
Mm-hmm.
Those are the dates that you wrote, correct?
I'm sorry, can you phrase your question again?
September 2002 to December 2002. You wrote, during this time I studied for and passed the United States Patent and Trademark Office bar exam?
That's what that says right there. Is that what's your question?
Okay, right now, why don't you answer this question, and then we'll take a break,
Okay.
a lunch break.
Just very small questions on this,
Okay.
and then I'll move, then we can.
Okay.
Is that okay?
Okay, that's okay.
Okay,
Yeah. Well, first let her ask one or two questions.
okay, sorry, you did state that in your letter, correct?
State what?
September 2002 through December 2002, during that time you studied for and passed the U.S. Patent and Trademark Office's examination?
Yes.
Okay. Yet, as you testified earlier, in fact, you studied for and took the July 2002 bar, correct?
I believe I took it, yes.
But you didn't include that in your update, did you?
I'm not sure. And further, I don't know that that is something required in my update.
Okay, so
And when you say update, I don't know if you mean just this one particular letter, or if you